Yes. No, it's not.
You want that in the picture.
So you're going to kick it off?
Sure.
You cannot have my wine.
All right. I think we'll get started if everyone's ready. Thank you for joining us on Monday night here when the football game is starting in an hour or so. It's excited to have Evolve Law and everybody in town here talking about alternative legal business models. Should be a good program, and Mary will get into a little more of the details here, but we thought it'd be a good fit. We have our tech conference tomorrow as well, so hopefully it's a good way to knock out a bunch of these hot button topics all at the same time. So if you haven't signed up for that, you can walk in tomorrow as well. But we're recording this, so if you want it again later, watch it again later, for the highlights or whatever, you can do that. So with that, I'll let you describe the program a little bit.
Okay, well, thank you, Joe. So Jules Miller and I started Evolve Law a couple years ago. Jules can't be here; she's in New York. But this is our first event here in Minnesota, and that's our tagline. That's what we believe in. We're a catalyst for legal innovation. We basically come into your town and we hold these events, and then we try to generate as much excitement and buzz around the use of technology, but it's broader than that. It's all about adopting and adapting to change. And so when Joe and I met at the March 15th pre-tech show event that Adriana, she was around here, so graciously invited Evolve Law to do an event before the tech show. We met Joe and he invited us to come do this, and our goal tonight is to record this, we'll post it, and to have everyone interact with our amazing panel. But I wanted to first thank some of our sponsors. I talked about you when you were out of the room, Adrienne. So how to manage a small law firm, thank you, Christopher. Everyone go over and see their poster because their collateral is a little bit MIA for a little while. And then, of course, Minnesota State Bar and Thomson Reuters, who sponsored this evening's event, and we have someone from Thomson speaking to close out the evening. So what we're doing with Evolve Law is we're trying to have these events. The idea is that we have our members and others here with tables. So please go visit our friends from the GLSA. That's a board that I serve on, so go visit them, Cosmolex, and the other tables. And I can't read Mary's organization is in Minnesota Legal. There we go. So please go visit them afterwards during the happy hour. But what we're going to do is we're going to have first, we're going to have Robin Wolpert come up and talk a little bit about what's going on here in Minnesota. So I'm just going to do a brief intro, and I shouldn't have brought my wine up here. I don't know what I was thinking. So
it's fine.
It's kind of awkward. So Robin is a legal strategist, a litigator. She is an appellate practitioner at, oh dear,
Sapientia.
there we go, Sapientia Law Group, and I'll try that because that's where one of our panelists is also from. And her focus is on complex business litigation, data privacy, constitutional law, political law, and she's also the president of the Minnesota State Bar Association. And what I did is I asked each of the participants tonight for an unusual fact. Now, Christopher didn't answer it, so I'm going to make it up for him when we get to him. But Robin just took, the best trip she ever took was to the Falkland Islands. And there's a bit of a travel theme in these unusual facts. So, Robin, we'll just go back to this if you want to tweet out, and I will follow stuff here.
So one of the reasons why we're having this tech conference is to address one of our bigger issues on access to justice here in Minnesota. So what we've been noticing is that with respect to access to justice, that we have existing legal models, we have huge disruptive, innovative changes across the country and in Minnesota, and we have to address the big question, which is how are all these firms going to adapt for the future? But one of the smaller issues, one piece of that puzzle is how do we enhance access to justice? In other words, we can unknot the whole Gordian knot, and part of it is increasing access to justice in Minnesota, but then we've got to also figure out how businesses, our legal services providers, can innovate and create new business models to survive in this, ever-changing kind of upheaval that we're going through. So what I want to do is give you an update on what our Alternative Legal Task Force is doing, because what we've decided to do is put together a group of really smart people who represent various sectors of our business and our legal services economy, and come together and figure out how can we solve this access to justice problem. And what they've been doing is they were constituted this year, and they've been meeting since February. They've broken up into subgroups, and they've been studying a variety of topics. They've generated a few options, and one of those options is to study the feasibility of adopting the Washington model, or some variation on the Washington model. And the Washington model, they've established what's known as limited license legal technicians. And they're not lawyers, but they do have an education requirement, they have malpractice requirements, they have ethics requirements, and they are regulated. But they would provide limited legal services. And so the question is that something transportable to Minnesota? Or is some variation of that transportable to Minnesota where we could actually make a difference and enhance the delivery of legal services with this additional provider? This task force has also been looking at the question of whether we should have, for example, enhanced paralegals, where paralegals could get trained and provide, again, limited legal advice under certain conditions. Is this something feasible for Minnesota? What would the cost of education be? What would the regulation look like? And again, would we be able to make a difference in terms of access to justice? Would these additional providers actually make a difference? So those are the bigger picture questions we're looking at. Right now, what's happening is our task force just came up with some of these options, and we're going to be doing regional shows across the state. So what that means is, I think there are 5 locations that have been selected, maybe 6, and they include places like Rochester and Mankato, Duluth, St. Cloud, I think perhaps Bemidji, and then Minneapolis and St. Paul. I think that's the list, or at least that's the list that's being contemplated, because we're still in the process of organizing those regional trips. And what we're going to do and what we envision is that those meetings will be about an hour and a half long, and there will be a short presentation regarding the options, and then the whole purpose is to generate conversation within that region of the state about what the impact would be of these kind of providers, to address concerns, make sure that we're aware of all the issues, because really we don't have a monopoly on knowledge. There's tremendous talent throughout the state, and so we want to have those people come to these meetings and assist us in working through these issues, but we also want to address concerns. For example, if we in fact increase the number of providers for the purpose of increasing access to justice, what are the repercussions of that for solo small practitioners, big firms, other legal services providers, the public sector? What's the impact of all of this if we actually create these new service providers? So that's what we're going to be doing. So that is the status of our task force, and I'm happy to answer any questions if you have them. Otherwise, I will cede the podium for the rest of the program. Thank you.
Thank you, Robin. Okay, so now we're going to bring up our panelists. The microphone's not in here because I can't seem to get it to work, but it's very distracting having that up there. Okay, we'll leave that up if you want to tweet. So we're going to bring up Christopher Anderson. Woo! Like a game show.
All the way up.
He's a proud father, husband, pilot, entrepreneur, and lawyer, and he has a singular passion for helping law firm business owners. Wow. See, I left my wine over there. I should have brought it up. Achieve success. I don't have an unusual fact. So, is there anything unusual you'd like to share about yourself? Not to put you on the spot, but.
No, I'm just very usual.
Okay. And then we have Mary. Other Mary. Oh, come up. Kaczorek. Is that close?
That's correct.
Okay, and so Mary is the supervising attorney at the Legal Services State Support, which is a project of the Minnesota Legal Coalition, Services Coalition. And her fun fact is that her last name actually means little duck in Polish. So that's cute. And then from afar, from the land of the Triple LT, comes Dan Lear from AVO. And he is a lawyer, writer, and legal industry gadfly. That's his self-described.
Yeah.
He does outreach and technology evangelism for AVO and runs the Legal Hackers Group in Seattle, also the Legal Innovation Group, right?
It's the same thing.
It's the same thing. Okay. And his fun fact is that he stayed at Robert Redford's beach house in Malibu. So that's pretty cool. Okay, and then we have Sonia Miller Van Ort, and she is a commercial litigator and founding member of the law firm that I cannot pronounce.
Sepenchi Law Group.
There we go. And that is a non-traditional women and minority-owned law firm in Minneapolis. So that's very exciting. And her unusual fact is that she's half Ecuadorian, and she's visited there 6 times, including participation in a dental mission during trip number 3. So that's very cool. So just gonna have everyone sit down. And so we have some prepared questions, and we can try to use the mic to see if it will help, because we are streaming this, or we were streaming it. Okay, you've just turned, okay, that's
Internet?
fine.
Hello, Internet?
Okay, so we're going to go through a few questions, but the idea is to have some audience interaction afterwards with your burning questions. And so we want to, before we get into talking about, before we blind the panelists, okay, you guys can arrange your chairs. So we're going to talk about a few things around alternate fees, and we're going to talk about, alternate payments. And we want to start off by talking about what we've all heard about a lot, the death of the billable hour. So can you just sort of, Sonia, you can lead this off and comment a little bit on the billable hour for billing versus alternate fees, and then Christopher is going to comment on that.
Sure. So we hear a lot about the death of the billable hour, and I guess I don't think that the billable hour is dead, but I do think it's aging and possibly arthritic. When we stop and think about why is it that attorneys bill by the hour, that's a question that we considered when we started our firm, really trying to think through why are we doing what we're doing, does it still make sense? And I always kind of liken it to when we go to medical providers. Do we think about the services they're providing and think about how much time they're spending doing it, and that's better, the longer that they spend with us, that's better? Or,
Especially dentists.
Right, especially dentists, exactly. Or if you're thinking about someone who you might hire to build an addition on your house, do you think about their services, that the more time they spend on it, the better it is? I don't think so, but yet as a legal industry, that has continued to be kind of the metric that's been used for a number of decades now. And I'm not sure that it makes sense. In fact, I don't think it makes sense when we look at what our clients' interests are versus what a law firm's interests are. A client is not concerned about how long you're spending on it, other than the fact that it just means their bill is getting higher and higher. What they want is the answer, what they want is the advice, what they want is the results. And having been someone who's practiced at a very large firm in town, and then a medium-sized firm, and now with Sepenchi Law Group, I think it's hard to deny that when you have a law firm model that is structured around how many hours you bill, and that is how we value our attorneys, that's an inconsistent interest with our clients. So, at least from our perspective as a firm, what we really strive to do is to offer alternatives to that. A client can choose to be billed by the hour, but we also try to give 1 or 2 other options to say, how do we align our interests with what it is you're trying to achieve and put pricing around that?
Me? Well, you just stole everything I was going to say.
I'm
So,
sorry.
that's okay. Listen, I mean, surveys have been done, very, very scientific surveys have been done, and they've understood that people would like to pay by the hour for 2 things in life, and 2 things only. Do we know what they are?
That's an open question to the audience.
To the audience. Molly, what are they?
You tell me, I don't know the survey results.
Anyone? Hands?
We only want to
Yes,
pay
sir.
for 2 things?
Cost certainty.
No?
Food?
Cable.
No? By the hour. Two things by the hour. The only 2 things after surveys were done, scientifically done, that people want to pay for by the hour are parking and sex.
Understand.
This went over very well, surprisingly, in Salt Lake City, and completely bombed in Oklahoma City. But it's actually true. To your point, your clients at the end of the day aren't interested, and this goes to how lawyers sell legal services. They're not interested in how much time it takes. And you're right, it's only been decades. Most people think it's like always been this way, and it's not always been this way. It started in the 70s, and we've become addicted to it. It was this drugs that have been foisted upon the legal industry by insurance companies and now by big business, and we have become addicted to it and lazy to it, right? And then so that's where it's going. So what I like to advocate, what I think that the solution to that is that we have to learn how to communicate value to the client. We have to learn to listen to the client and understand where they find value, and then communicate that value to them so that they can understand where the value is in buying the legal services. That helps us align our interests with theirs. That's my initial comment. 2 minutes, right?
Yeah, very good.
All right.
So Dan, I'm just going to skip down just because Robin brought up the Washington LLT. So can you tell us a little bit about it and you know, anything you know about the experience? Because it started off in family law, and I think it's still only family law, right?
Yeah. So they started in family law. I think the plan is to move next to, maybe you know,
Robin's over there. Is it?
I'm not sure.
Oh, they plan to move next. I'm gonna forget, but I know that they've already targeted the next area.
Elder.
That sounds right.
Elder
That sounds
law.
right. Yeah. So they plan to move to that's the next area of law. I mean, I think I can talk about how it's regulated. I can talk. What do you want to hear?
Well, these are the folks in Minnesota who are looking at
Sure.
this. Like, how do lawyers in Washington feel about it? How's it?
That's not a hard question to answer. I mean, let's step back and I'll try to tie what we were talking about here to that. So in 2 minutes, of course. The first thing is what the program is set up to do is to provide a different model of service delivery that doesn't currently exist at a different price point, right? And maybe it's more the different price point. I don't know that they're being any more creative about how they sell their services than lawyers are, but ostensibly it takes less training and less brain development, and that's not to say they're any less smart. I'm just saying they don't spend years and years and years in school. They don't have to pass the formal bar association or bar exam and learn about Indian law in order to deliver legal services. And so theoretically it should bring the cost down and give another option for, you know, instead of the billable hour, or at least at a different rate, to have those services delivered. Lawyers, I think for the most part, those who are aware of it are not fans of it, not surprisingly. They want to keep the walls of their monopoly firm and high, which is understandable. I'm a lawyer. There's lots of reasons that makes sense. I think politically what happened and the way it came about is, I think, what's most interesting, which is kind of akin to what happened in the UK, where the legislature came in the UK and said, hey, you're not serving the public, so we're going to jam the Legal Services Act down your throat and we're going to take away regulation from you. That's not what happened in Washington. It wasn't the legislature, but it was the Supreme Court, who is our governing body for legal services, said this is something that needs to happen in order to expand access because we have a significant access problem. And for whatever reason, the methods that lawyers have developed to bridge that gap are not cutting it.
Okay. So Mary, we'll just jump to you. What you know, with legal services, and is there alternate delivery you have? You know, you can talk a little bit about your project in the coalition as an alternate model of solving the access to justice.
Yeah, absolutely. Is this on?
I think
It's for the people on the internet.
Oh,
who may or may not be seeing us at this point. We're not quite sure, but we do have it being recorded.
I look a lot cooler and I have more authority with it, right?
Yeah, exactly.
So I'm with the Legal Services Coalition, and we launched an online advice website in 2014. The ABA has taken this idea and has launched it nationwide, so I think over 40 states have something similar, or will have something similar shortly. Basically how it works is low-income members of the public sign up and see if they're eligible, answer a couple questions, and then post their legal question online. Attorneys then can sign up, make an account, look at the list of questions, plug one out, and correspond with that client individually. I apologize for the people who have already heard me say that exact striker sentences like 5 times today. But it's great. It's a great way to connect clients who really need help with attorneys. Clients can get to it anywhere they have an internet connection. Attorneys can get to it anywhere they have an internet connection. So some of the obstacles for a lot of legal aid's clients, like maybe they don't live near a legal clinic, maybe they don't live in the Twin Cities, maybe they work during business hours, all these barriers that may prevent them from connecting with an attorney kind of are taken away. And it's also a great way to supplement the work that Legal Aid does. So Legal Aid in Minneapolis has to turn away 2 out of every 3 otherwise eligible clients because they just don't have enough attorneys to meet the client need. And so this is a great way to connect pro bono attorneys or people who might not be volunteering already to start volunteering and help, increase access to justice for legal aid's clients, who are some of our most, underserved and vulnerable people. So that's my pitch. Volunteer, sign up today. mnlegaladvice.org.
So Christopher, can you talk a little bit about, from a small firm, and what can we do differently in terms of delivery models for including the use of technology tying in with tomorrow's conference?
Yeah, so, when you listen to what we've been talking about so far, and, the pieces have been laid out on the table already. And we are facing the fact that the billable hour is still alive. We're facing that there's a huge number of people out there who are seeking, needing, wanting legal services and going unserved. And we're wondering, and then we're seeing places where in England they're jamming it down their throats, and in Washington the Supreme Court said you got to do something about this. And we're all wondering, how do those things fit together? They exactly fit together. As long as a monopoly exists, as long as we focus on the billable hour, as long as lawyers try to hold that old way of doing things together, people will be underserved. But just imagine what happens when you communicate value, when you sell legal services. When you say you've got a problem, because by the way, first of all, let's get over the fact that nobody in the history of law has ever hired a lawyer to solve a legal problem, ever. That's not what people come to lawyers for. They come to solve personal problems every single time. If it doesn't affect their pocketbook, if it doesn't affect their calendar, their time, if it doesn't affect their reputation, they don't care. They come to solve legal problems. And once we understand their problems and give them solutions that are based on the value of their problem and solving that problem, all of a sudden, we have a huge incentive to do it efficiently. And once we have a huge incentive to do it efficiently, we'll be hiring these quadruple L, triple L.
Branding is poor. Not my vein. I'm just a messenger.
The LLL people.
Triple LT.
We're going to be bringing them in-house. We're going to want that as part of our team as to how to deliver legal services. So how does that relate to small firms? What's going on in small firms that is exactly relevant? LexisNexis, while I was there, we did a survey and found among firms of 20 and less that 40% of the time they spent not doing marketing, but sitting in the office supposedly doing legal work, 40% of the time never made it onto a bill at all. Clio just came out at their conference with a report that is data-driven from their customers on their websites. It's not scientific, but it's a pretty darn big data set. That on average, the solos that are practicing with them, the lawyers that are practicing with them are billing 2 hours a day. And we're holding on to this thing called the billable hour that's not even serving us. We're billing 2 hours a day out of 8-hour days. This is not working for us, it's not working for the public. And when you look at it from a small firm perspective, it's just not working for small firms. Turning to a value-based way of thinking about things is going to be better. What technology can help? If you want to bill by the hour, you can use Chromita. You can use technologies that actually track what you do. In my firm, actually, we hired a law clerk to follow us around and write down what we did. And that sounds absurd, but it's actually hugely advantageous. If you're losing 40% of the time that you do, how much time does a $10 an hour law clerk have to capture to pay for their $80 day? Not very much, right? They have to capture another quarter hour of your work. Just have someone follow you around, but that just highlights the absurdity of the whole exercise. The real technology is in tracking your SKUs. And I know this is over 2 minutes, but I'm just going to keep it. In understanding what you deliver. When you deliver value, you have to be able to deliver that value for less than it costs. So when you want to deliver value to a client, you want that client to get more value from you than what you charge them. They should make a profit. But then you've got to make a profit in delivering the legal services, so you've got to be able to deliver it for less than you charge them. And the way you do that is to understand every piece that goes into delivering that service and drive efficiency into that process by understanding how you put the process together. Most of what we do is repeatable. And once we understand how to repeat it, we can deliver value to our clients.
Okay.
Small purpose stuff.
Excellent. So Sonia, can you tell us a little bit more about the alternate delivery methods that you use at your firm?
So I think that why I'm on the panel is just because Sapientia, what we tried to do 5 years ago when we created the firm, like I said, was to kind of look at a lot of our personal experiences working in large law firms and looking at what I would call flaws to the traditional law firm model and trying to say, okay, if you were going to start over, how would you address those issues? And of course everybody brings their own filters in. So for me, my filters are having worked in a big firm and seeing many friends leave the practice of law. A lot of times it's women, a lot of times it's minorities, not exclusively, but disproportionately so. So why is that? What about practicing in a private practice leads to that? A filter of working in a firm where I can see very competent, hardworking attorneys who developed a big book of business, but not being valued because their hourly rate isn't what somebody else's hourly rate is. And to step back and say, does that make sense? And why are we so driven as lawyers by the billable hour? Why are we so driven by our rate? It has to go up every year. You got to keep it. And I'm pretty sure that the clients who hired me 5 years ago expected me to be good then. Not, well, when she's $450, then she'll really be good. I mean, they expected me to be good when I was $300 an hour, right? And so these different perspectives, what's driving this and what seem to be flaws, I think, in the system is what we tried to figure into Sapientia. So it was mentioned in the intro, we are a minority and women-owned law firm. That's a key cornerstone to our firm. And I think it's important because we've lost many women and minorities who I think are excellent attorneys who have been driven out of private practice. Whatever the metrics or the system has been, and I think it's a waste of talent. So how do you create a law firm structure that values that and that creates a system that works for the working mom or the working dad? That's one issue. Another issue is how is a law firm managed? And at least in my experience, it's been managed by those who have the biggest book of businesses. And while that is an important aspect of any firm, you have to have people who are driving business. Those people aren't always the best managers, in my opinion. They're looking at different things and not necessarily managing the business. So how do you create an environment where you can be more of a strength-based leadership model as opposed to who's bringing in the most money? Again, I don't mean to discredit that because it's super important, but it doesn't mean that you necessarily are a good manager. How do you deal with the issues of originations? Huge issue, right? Who originates the work? Who's doing the work? Who gets credit for the work? How can you create a system where that's not the issue, that everybody is more focused on who's getting credit for something as opposed to how do we work as a team to get the best results so that we all benefit? And we've tried to employ different strategies in doing that. So those are the things in which I think that we've been innovative, different, try to approach things in a different way. The alternative fees are a huge part for us in thinking about how we're delivering our services to clients and how do they find value in that. How do you align interests? What's success to clients and what does that mean for your performance? But I think a lot of it is maybe an altruism perspective in terms of how do we make the profession better? how do we create a system where people enjoy practicing law, where we really enjoy what we're doing, and we're also crazy busy, and I can't say that I'm working any less than I ever did before. I'm probably working more, but I feel more satisfaction out of it, and I feel like I have a great team. And Sapientia is a work in progress, and it may not, ultimately, it's a case study. Will this work? And it may not, but I know I feel passionately about it, and I know that my team does. So we're trying to do things a little differently.
So Dan, we're just jumping back to something you talked about before with the UK. If everyone, and if Mary wants to jump in on this or not, we talked about it in the prep call. If law firms were to be owned in the US by non-lawyers, what do you think that would bring to the profession or detract from the profession? Sort of give me your take on that.
Yeah, that's a super big question. It's a really big question. I mean, I think it just goes back to incentives. And capitalism, in a market-driven economy, people respond to incentives. And so it's really challenging in a solely lawyer-owned environment to create incentives that make people respond appropriately. And I know that a lot of big law firms will disagree, but I mean I was on a panel at ILTA a few weeks ago, and I sort of said, like, when was the last time you heard a computer science graduate from MIT say, the sector that I'm really interested in is legal, right? Like, for whatever reason, investment banking is interesting, Silicon Valley is interesting, even med tech, ed tech, they're all interesting. But and I'm not putting that purely on the fact that we don't have non-lawyer ownership, but I think that that's a piece of it. I also frankly think, and this is just my opinion, but I'm listening to you folks talk and talking about strengths-based businesses, right? That's the way that every other business in the economy runs, right? There's no counting, right? Salespeople get compensated according to a structure that compensates them as it relates to sort of how many sales they do sometimes, right? But we've already figured out comp structures for roles throughout the company, and so to think about, and I guess where I was going with this is what you end up with at a law firm is a two-tiered system where lawyers control the revenue and control all of the business, and everyone else is basically a second-class citizen. And to me, I think that's the most, frankly, offensive, but also the most kind of challenging thing that we as lawyers and law firms have to face moving forward, is that if we want to succeed, if we want to grow our businesses, if we want to build 21st century law firms, we have to recognize the importance of design. We have to recognize the importance of technology. We have to recognize the importance of sales, like legitimately. We have to recognize the importance of project management. These are all pieces that are integral to modern businesses. And I think the verdict is still out on whether non-lawyer ownership is going to fix that. But I fundamentally believe that if we do not create more equal, flat, egalitarian structures, that will be our undoing.
Christopher, and then
Mary? Yes.
Okay.
And from our business perspective, I couldn't agree more. But let's also talk about the consumer. What does non-lawyer ownership do for the consumer? Again, we are trapped right now. Legal. I mean, we look at this. We got 41,000 or 49,100 and something dollars is the median income for a solo lawyer in America today. Half of lawyers are making less, and they're walking around saying it's tough out there. And then, what percentage of people are turned away by legal services?
Anywhere from 60 to 80.
Yeah. There's this unbelievably underserved group of people. Now, when you turn non-lawyer ownership into any other business, what do? They go and seek the market. They find the market and they get over themselves. right? They find a way to deliver, listen, you know what? I'm sorry, some portions of the community might not be able to eat at, what's the best restaurant in Minnesota? In Minneapolis?
Applebee's.
Best restaurant in Minneapolis.
Can someone escort the woman in the front?
McCormick and Schmick's is not the best, but the one I saw today. You know, sometimes people have to eat at Applebee's. Sometimes people have to eat at McDonald's. And they could choose to do that. And there are businesses that said, you know what? I am going to build this hugely successful business that caters to people who want to spend $5 a meal. And I'm going to be really successful at that. And that's what my business is going to be like. But without non-lawyer ownership, nobody wants to be there. Nobody wants to do that. Nobody wants to gain the efficiencies that are necessary to deliver that. Listen, non-lawyer ownership is not going to. There's a lot of things that investments solve for other businesses. Legal's not a capital-intensive business. We don't need capital to grow our businesses. What we need are processes and an incentive to deliver repeatable processes. I don't know if anybody's read Susskind's works, right? But you know, Susskind talks about bringing, what's he say, from bespoke work to standardized work to systematized work to packaged work and finally to commoditized work. And we see that as like a demeaning of our profession, but it isn't. If anybody reads Seth Godin, if everybody understands what really happens when you commoditize the work, is it liberates us to practice our art. If we can operate a business that can deliver the commoditized work for an affordable price, we get freed to deliver the art and to really help people in a deeper way. And I think that's what non-lawyer ownership can do, is to force the business to get more efficient, to deliver more efficient services to the people who are out there clamoring, suffering for the lack of it.
Thanks. Sonia? Mary's taking a pass.
I don't know that I have too much to add on that. Great comments. But when I think about it too, just like when you think about the normal business world and that it's filled with innovators, and when you think law firm, the word innovation never comes up. So, right? I mean, it's almost oxymoronic. So, how do we get innovators in the profession? Because we weeded ourselves out, right? The innovators went to business school. They probably didn't go to law school. I mean, we're the most conservative group there is, right? So, how do you get some of those thought leaders into our industry to help us? And that might be part of the way. You know, there can be different regulations on it. Maybe they can't be a majority owner. Maybe I mean, there are limitations that could be set, but it seems to me that to infuse our industry with more creative thoughts and processes, we have to look to the businesses that are doing it, and most law firms don't. So it seems to me that that is potentially an upside for us.
I actually have something to add. I changed my mind. I do want to talk. So two things came to mind as both of you were talking. First, so commoditized, is that the word?
That was the last one.
And innovating. So legal aid has had to do a lot of both of those things just because we're so strapped for cash. Donate to your local legal services organization, everybody. And so an example that came to mind in the work that we've done, we have created do-it-yourself legal forms, right? So it's something that someone who, you know, may have low literacy skills, definitely isn't a lawyer, may not know a lot about their legal issue or that they even have a legal problem, maybe they just think it's a problem, can, you know, answer a bunch of questions, put in their information, and then at the end the system will spit out a document. So we just created one for someone to expunge housing court records, which would, you know, enable someone to get housing. And so I think there are a lot of really good examples just in the legal services field of things that have been done to, you know, help meet that need.
Great. So we talked about it a little bit, and we have GLSA over there, which is Group Legal Services Association, which is the prepaid legal plan. So what do you think, you know, how can legal plans or subscription models help with the access to justice? So this is open to everyone who wants to comment on it. If Mary wants to comment now or at the end, she can.
Got it.
They've been done poorly. I mean, I've served on several panels of legal plans. I serve on the Aircraft Owners and Pilots Association legal panel. I've served on Common Council, I think it was, whatever. They've just been done poorly. such that there's not the resources in the plans to actually deliver quality services. And it sounds like insurance and it looks like insurance, but it's not, right? And so what it ends up being is it's a great marketing tool. It's an entree to get people to get a taste of my services, and then need more, which they have to hire outside the plan. And I'm forced to give a 10, 15, 20% discount, which is fine because if you refer me business, that's what I pay anyway. But so it's a marketing tool, but it's not a solution. Bless you. But it's not. But I'll take that as agreement.
Yeah.
But to me, it's not. It's a step. It's a dabbling in bringing business to the delivery of legal services, but it's not enough, and it's a very thin veneer over a much deeper problem.
Yeah, so I mean, I'll be a little fairer. I think anything that gets us to deliver services in a different mechanism is a good start.
Sure. Right?
And I think for some people, the legal plans. I mean, I know of some business owners who've gotten some real value out of it. We, for what it's worth, and this is not a plug for Avo, just to give you a sense of how we think about this. We don't have a legal plan. We did research, and we concluded that consumers preferred flat fee legal services, right? They preferred the transparency and the clarity and sort of the notion of, hey, this is what I get, it's in this package, this is how it works. That's the way we went based off of our consumer research, so we went a different direction based off of our research. But I think the more we can think about different ways to deliver legal services all along the spectrum, I think that's a good thing. And to your point, right? If it's a good marketing tool and you get somebody in the door and then you're able to convince them that, hey, like either your plan doesn't cover this or actually you need this thing that that is not otherwise covered by your plan. Again, it's like capitalism, right? Like we have two willing participants agreeing that value can be exchanged. That's a good thing. So I think that anything we can do to get people to engage more, to understand that they have legal issues and potentially to increase access, I think that's a good thing.
And I think if Sonia could also comment on it from the client's point of view. Like if I'm the customer, so I join a company and my company has a legal plan, then it is insurance. It gives a little peace of mind. So if you think of it from the client, it can be helpful. I think personally a little biased because full disclosure, I'm on the board of the GLSA, but it's one of those things that I do believe helps improve access to justice, although the reason I'm on the board of the GLSA is to try to help improve some of the technology aspects that can help commoditize things so that people can get enough and not have to pay outside of the plan. But I think it's a win-win-win, so it's my plug for GLSA.
So my perspective isn't necessarily related to subscription plans as they relate to access to justice, but subscription plans as an alternative fee arrangement that we do for our private clients. So I mentioned earlier, our goal is to be a leader in terms of alternative fee arrangements and being an expert in how to offer those and to be profitable at those. So one such mechanism is a subscription fee. And so the way that we've used that, because really what drives, from our perspective, alternative fee arrangements for our clients, and most of our clients are businesses, is budget certainty. That's huge. That's what they're being measured on, their ability to stay in budget. And so if we can provide a way for them to do that, it's not necessarily about having cheaper rates or costing less. And I know that's often what people think of when they hear alternative fees, but that's not really our perspective. Our perspective is how do you package pricing in a way that's more palatable to our clients in a way that works for their business. So back to subscription fees. The way that we've used that in the past is with, for example, a company that we've done work with for a number of years. We're able to look at the data of what we've done for them in the past, and we can make reasonable assumptions about what we can anticipate. And it's litigation, I'll throw that out there, because most people think litigation, you can't do alternative fees, and I will push back on that. And we basically have a plan for an annual plan of this is how much you pay each month. Here are the expectations. That I try to draw an analogy between rollover minutes with your phone. So you're going to pay X amount for your data plan, right? And it's going to include this many minutes. And once you go beyond those minutes, then you're outside the plan and it's gonna cost more. And that's basically how we do it. So the client knows how many hours are basically accounted for in the plan, and if we go beyond that, then it's something else, but otherwise, that's the time that they're paying for. So to your point, yes, there are lots of different ways I think that you can structure your pricing and think about it differently, and subscription plans from our perspective is just one of those ways.
Yeah, and I was just going to quickly say, I talked about this, I spoke at the law school earlier today. I definitely think that subscription plans for lawyers as a product offering to your clients is a really interesting idea. The one I talked about this morning is the Counsel for Creators, Jonathan Tobin out of LA, who has the Creators Legal Plan. And it's $95 a month. They get, I think, as many sort of email questions as they want. They get access to a document library that he has, and a couple of other things. And that's all about just figuring out, right, which we know that the cell phone companies have done tremendous analysis of like, here 95% or 90% of our users use this many minutes or this much data, and so they price everything accordingly. So they're making money, and you hopefully feel like, maybe you do feel like you're getting screwed by your cell phone company, but hopefully you feel like you're getting value, or you could switch carriers. And similarly, the same as with lawyers, right? They feel like they're getting a good value, and I think it's great. I was mentioning this morning, like one of the biggest challenges, and you could talk about this all day long, for small businesses and for small law firms is cash flow certainty, right? You never know when you're going to have a new client walk in the door, when you're going to win that big case. Well, these subscription plans are a great way to give you a recurring set of income every month to then build off of. Now, again, don't just start a subscription plan without doing your research. You have to think about how you do it. But I think it's a really interesting idea for law firms to offer, just as a separate way to think about that.
Cool. Okay.
Can I talk about that all day?
No, you cannot. So we wanted this to be a little bit interactive. When we have smaller sessions, the first time we're ever in a region or a city, I don't know what to call this because we're in a country club. That we want the audience to interact and chat. So if people have questions, please put up your hands. Our panelists will be happy to answer them. Does anyone have anything they want to talk about, ask?
May I ask a question without being ejected?
Yes.
No, I'm curious
Does it involve Applebee's? Because if so.
I'm curious about Sepentia Law because we didn't really talk about what your different model is, or, I mean, gathering from what you have said so far, it sounds like did a bunch of female lawyers come together and decide to create this different model of a law firm? Or did I not get that right?
That's a good guess, but no, it's not exactly right. It's a very diverse group, and it's not just women. Okay. So we've got people all across the board, and I always say we have white men in our group. We are very diverse. From our diversity ranges in age and experience and ethnicity and gender. It's very broad. But really the commonality, I would say, is that we shared experiences working in bigger law firms. About half of us had worked in big law firms, the other half hadn't. They'd worked in small firms. And we are 9 attorneys. Currently, we've been kind of between 9. We started with 7. We've been kind of fluctuating between 9 and 11. And we generally represent, as I said, businesses, but sometimes individuals. It's largely litigation. A smaller portion of our work, about 30%, is transactional. And for each of the last 5 years, about 55% of our work, our business has been generated from alternative fee arrangements. So we are using them daily.
I have one. So going back to the very beginning with time and billing and the billable hour, when you're going through school and you started a firm, you hear, 0.6, every communication matters. How do you set the expectation with your client under a different model as to what they can expect from you? If it's, like you said, it's not a legal issue, it's a personal issue. Someone calls at 10 o'clock at night, this is what's going on, and we have to keep track of that. So when you're talking about a subscription or a different pricing structure, what do you do to set the right expectation, or do you change the boundaries of communication with you and the client? It's anybody.
I'm like jumping at this one, but
Go
I'm
for
sure
it.
you are
Okay.
too.
Well, you can all
Yeah.
answer it. You can all answer it.
Well, I mean, Chris said it. It's sales, right? You know that you're getting a certain type of service when you go to McDonald's, and you know you're getting a different kind of service when you go to Nordstrom. And so it's really about helping. Now, let me step back. There are some caveats and pieces that are probably worth mentioning. So it depends on the law firm you're at, first of all, right? I was at what I would have considered a fairly nimble law firm, and loved my partners. They were great folks. And to be clear, they were the partners of the firm. I was not one of them. Otherwise, I maybe would have made different decisions. But I came to them with what I thought was a pretty innovative alternative fee arrangement for a client. And basically, they said, we always lose money on stuff like this. These never work. What happens is you as the lawyer bear all the risk and the client gets all the benefit. So you have to get into an environment in which structurally the firm can handle you coming up with something that's a little more creative. That's the first piece. And I think that's an important piece to mention, right? Because there's lots of law firms that either structurally or institutionally or emotionally don't have the fortitude for it. But after you get past that, and again, I would say, and it sounds like you guys have done some research, I will quickly pass the microphone off to you, but there are lots of ways that any other business, every time McDonald's sells a hamburger, they know how much money they're making, right? Every time anything goes off the shelf at Nordstrom, any other business knows when they sell something, they know how much it costs to produce and they know how much money they're making. We should not be an exception. And so it's really just a matter of figuring out what is it that I'm selling and how is it that I can sell this in a way that works for me in a variety of ways, right? And you may never avoid the 10 p.m. call, but dang it, they better be paying a premium for the 10 p.m. call. Because if they're not, then you're losing out, right? And look at it from an economic perspective, not from a client service perspective. The other thing I will just quickly say, I actually don't think that the billable hour should be dead. I think that again, in a market economy, there are lots of great ways that if I want access to the nation's foremost expert on blah, and that person is so expensive that he can charge me or she can charge me by the hour, bless them. Right? I think that there's a way that model works, and I think there are a lot of smart lawyers who say, hey, I have my, this level of service and this level of service, and if you want, you can opt out of that, and you can get me by the hour, but it's going to cost you.
Absolutely. The market is always right. Whether the billable hour goes away or not is depending on what the market wants. The answer to your question, quite simply, is that the reason, how do you sell it differently, is you sell it differently. Most lawyers, if you look at their websites, if you look at the way they talk to clients, their sales conversation is mostly about them, right? Their website says where they went to school, their latest case, how awesome they were, and then the client comes in and they're like, all right, here's what we're going to do. First thing we have to do is we have to file this and this and this. We're going to slam that down their throats. And then once those are filed, we're going to take this and we're going to go over here. And they walk you through the sausage factory, and the client says, I don't care. Talk to me about the thing I care about, me. The way you sell the non-billable hour is to actually have a human conversation with your client where you understand three things. Let me just understand first of all, because you know what? The client doesn't understand. You have a conversation where you help the client understand, how is this impacting your money? How is having this DUI, this divorce, this contract that you should get done, this opportunity to file a trademark, how is this impacting your money? How will it be better if you do the work with me or a lawyer just like me versus not doing anything? Good. Now that we both understand that, let's talk about how working with me can impact your time. Are you wasting time worrying about this? Are you wasting time trying to do this on your own? Are you wasting time doing this wrong 3 times before you came to me? How is this going to impact your time? Learn more about that and help them learn more about that. And then how is this impacting your reputation? Is this DUI impacting your reputation? Is this inability to get a contract done in a timely manner with your customers, impacting your reputation in the business community? Is this impacting your reputation in some way? Let me understand that. Okay. So if you don't work with me, these are the problems you're going to continue to have. And if you do work with me, here are the problems we're going to solve. The difference between those two places is the value of my services. Now let me price it at a fraction of that so you make a profit. And now nobody's talking about hours. And in that whole conversation, nobody's talked about me. They've only been talking about you. And that's the way you do it.
Okay, so, no.
30 seconds. Oh. Mary, please, I've been so good.
All right, 30 seconds.
So
we've been on a lot of
yeah. Mary owes me. So my father, who was the total accidental law partner, I'll explain that later at some point, said, if there's one thing I've learned after 30 or 40 years of being in business, it's that my clients can help me achieve what I want to get done if I help them achieve what they want, right? And that starts by having that conversation, but I think so many lawyers approach their client relationships from an adversarial perspective. It's like, how much can I squeeze out of this right away? And that you're doomed from the beginning. The other thing I will quickly say is having that conversation also requires a higher level of business understanding, because you have to decide, if you've got a lawyer sitting in that room asking those questions, if you're operating under a 0.6, hours out the door model, you're already costing yourself money. So you have to figure out, how can I have that conversation and still have it be cost effective? So again, it requires this higher level of thinking and this more thoughtful way of approaching all of this before you even have that conversation. Otherwise, again, you're losing money. So you've got to be smart about that.
Okay, I think that was more than 30 seconds, but I don't have my timer up here. But I think a theme that is coming out of all of this is that it's the clients that come first. And I think Dan mentioned this sort of two caste system that you have in law firms. I was the dreaded staff for a while, so I know what that feels like. And as a business person with a business background and a law degree, but not a practicing lawyer, I mean, I look at it and I look at something like the triple LTs, and I think the L is for leverage. I mean, you can, as a law firm owner, you can go out and hire these people the same way you should be hiring paralegals and associates, and then that way you're keeping all the really cool, the professional judgment, and that whole thing is what you all went to law school for. And you get to do that cool work with your clients. And I can tell you, I had a flat fee model when we first started my company, and it was really great because there was a certainty, but also I didn't hide things. As a person who went to law school who doesn't practice, I'm dangerous as a business owner, because I think, oh, I can just take that and I can just tweak that employment letter and use it, and that's really dangerous, right? But when you have that flat fee model, then you feel like the subscription for Jonathan Tobin's firm, or as I'm hearing from Sonia's firm, is that you wouldn't hesitate. And I think that makes a happy client. So a happy client means profitable practice. So does anyone have any last questions? And then maybe each person on the panel could just give us in 20 seconds or less. So would they think how technology can be a change agent within legal, unless there's another question from, we do have a question.
Oh, I could ask a question.
Sure.
You're all generalizing about the legal profession as though it's a monolithic entity, and it's not. There are entrepreneurial lawyers in law firms. There are a lot of law firms that work on fixed fees in certain practice areas because that seems to work or it's required. There are a lot of law firms that work on contingent fees, and so there's no regulatory barriers that say you must bill by the hour. There is a herd effect. There's a timidity among a lot of law firms that are at the so-called pinnacle of the profession that then everybody copies, but it's more cultural than it is economic. If the marketplace is always right, question whether that's overgeneralization, but if it is, then the marketplace would be telling mainstream business-oriented law firms that they make more money doing it the way they've always done it with the billable hour than they would if they switched to value fees, either because they have no clue how to figure out what the value is, or because, and I actually have said this for years, I actually think that in many cases the hourly rate and the publication of the hourly rate across the profession props up the profession's profit, and the true value of a lot of the legal work that lawyers provide is below the hourly rate, and it's kind of a giant informal price fixing, collaboration that allows, because they will say we aren't going to veer from the hourly rate. If it was more profitable, people would rush toward getting away from the hourly rate. The whole time keeping record process in the first place, people adopted because they thought it would be more profitable than when they lost. Yes, they did.
No.
That was the rate.
Okay, so I'm not sure I'm hearing a question in here, so I'm just looking for the question, because then we want to have 30 seconds from everyone. So was there, like, it's all interesting, but is there a question?
Well, I'll just super quickly say, I think that the market is responding because a lot of consumers are going around lawyers, or they're not consuming legal services.
Have you heard of legal
and I think that's a significant, because I think consumers who, they're not buying what we're selling. That's a big problem. And second of all, and I really do believe this, if we can't figure out the access problem, we will be remade from the outside. And I don't know that we want that.
80% of people aren't being served
And-
by legal
So
services.
I already went overtime, so if anyone.
So
Then,
it's not a functioning marketplace. The market is always right if the market's allowed to function. The market's not allowed to function because we have unauthorized practice of law. We've got the barrier to entry to delivering legal services. There is no market. You're absolutely right. There is a ganging up effect. There's a, I forget what the word you used.
Herd mentality.
Herd mentality. But don't forget where the billable hour came from. It didn't come from lawyers. We didn't invent this. This was put upon us by insurance companies. They said, if you want to do business with us, this is how you're going to do business. And we learned that it was easy money. And we followed the leader. And then big business got into it. So now you've got huge industries. I worked for one of them that deliver billing systems to teach lawyers how to bill properly so that the big companies will pay your bills. And it's all around this billable hour. But we didn't invent it. And it's not, you're right, the value sometimes is well under the billable hour, and sometimes it's over. Because we don't price by value. We price by, and I'll just make one more comment about the billable hour and why it's going to screw us all if we don't get away from it. And that is, we are selling the one and only thing that exists in our lives that is finite. There is no limit to the value we can create in this world. There is a limit to how much time we have. Why would we sell that? That's my last comment.
okay, Mary, did you want to add something? And then Sonia, and then we're going to get the slides going.
Slides?
Slides, not for you.
No.
Slides. Darwin talks.
So again, I'm coming at all of this from a poverty law lens, and a lot, we're talking about clients and paying and all this stuff. Most of our clients can't pay, and so at Legal Aid, we're thinking really big, and we're thinking about, okay, how are we even setting up these processes? Why does it take a lawyer to do something that someone who could, feasibly do on their own? Why aren't these forms written in plain language? Why do we need a lawyer to read, these documents? So, I guess my pitch is just to think about, all of the members of our community. So that's a lot of, people who can pay, and, a lot of, firms, clients, our businesses, but then there's also a lot of people, in our cities and where we live who just can't afford a lawyer, and what can we do to make sure that those people's needs are getting met as well? So,
Okay, Sonia.
Can I pitch Legal Aid one more time?
No.
Yeah.
No, I'm saying,
Do it.
and Legal Aid.
So, Laverne, I thought you had some interesting things to say, and I guess only to that point, as I've said, we kind of approached it as, how can we try to recreate and reinvent how we deliver our services? And there's a lot of people who will say, and I will say that again, our profile of our ideal client is a business, and we do work for Fortune 500 companies, and then all the way down to startup companies. There are many companies who will say, we want alternative fees, but they don't. They don't. And part of it is the fear, part of it maybe is they feel like they're not really getting the value. And so I don't know that I have good answers. I know that we're trying different things, and I think we've had some successes, but it's a big question. But what I do know is that we really have to put aside our traditional way of thinking. We need to put away the partnership mentality, and we need to think about our law firms as creative businesses, and how can we be cost effective and efficient. And that's where technology comes into play, I believe. But it goes beyond technology. To me, it goes to the metrics of your law firm. What are you measuring? What are you valuing? How does that relate to how you're compensating, or how you're compensating people? Because it's all tied together, and you can't effectuate many of the changes we're talking about, if you mentioned this, Dan, if you don't have the environment that is receptive to that. So creating the environments that are receptive to it, I think, are key.
Well, I want to thank the panel, and we're going to bring up, so thank you. So now we have what are called Darwin Talks. We're just going to do some quick little tech stuff here. They're 5-minute. I don't yell at people like I yell at Dan, but they're 5-minute little talks. They're supposed to be thought-provoking, and then afterwards, while you're going around to check out Cosmolex and the technology and chatting with each other, you can talk about what's going to be said. We're continuing the theme with Lindsay Davis and Sherry Canoe. Thank you. And they're going to come up and talk about alternate fee arrangements and unbundling, and then they're going to be followed with David Kroll from Thomson Reuters, our sponsor for this evening, one of our sponsors. But so I'm just going to briefly introduce Lindsay and Sherry. So Lindsay is Minnesota State Bar's Access to Justice Director, and she was previously a legal aid attorney, a private practice attorney, and an adjunct professor. So an unusual fact is that her daughter has been able to cross her eyes since she was 2 years old. She wonders if this is normal. That would freak me out as a mom. And then Sherry is also with the Minnesota State Bar, and she's in charge of government relations, and she's the membership engagement director. She has a JD and a master's degree in public affairs, and is a lawyer, writer, lobbyist, and political advocate. And continuing with our travel theme, Sherry just came back from a 7-day bike trip on Costa Brava in Spain, so that sounds lovely. So I'm going to sit down with my wine and let them take it away. Am I in the way? Oh, sorry, yes.
Okay. Great. Hi, everyone. Thanks for sticking around. I have an extra drink ticket if anyone wants one. So I'm the Access to Justice Director at the State Bar Association. So it's a really cool job because I get to see the intersection of where business practices meet legal aid, and it's a really interesting intersection that we have in the state here. So first, I just want to talk about why alternatives. I think the panel has already touched on this. The need is huge. Legal aid is turning away 66% of eligible clients due to a lack of resources. Another fun fact about Minnesota, 27% of our population lives at 200% of poverty or below, meaning they qualify for public assistance. That's over a quarter of our population. Client expectations are changing, right? We all have Roku and Our Car, things like that. The commercial sector is responding quickly, as you're seeing here today, and as you've heard from the panel, like Avo and things like that. Another fun fact, courts are constantly improving their self-represented litigant services. I work pretty closely with the Minnesota Judicial Branch with the Access to Justice work, and they have a huge push right now to increase their e-filing initiatives and self-represented litigant services and self-help centers, because they understand that the private bar is just not meeting the need. So that's something to be aware of, to prompt us to think more about alternative fees and unbundling. And there's one other thing that hasn't come up tonight, but it's also important, is the Justice for All national movement. Is anyone here familiar with the Justice for All initiative? Yes, thank you. So this is an initiative from the National Center for State Courts and the Conference of Chief Justices, coming from above, which is trying to fund innovation and improvements on a state-by-state basis. And the principle is that every individual who needs legal assistance gets some type of meaningful assistance. And the Public Welfare Foundation is funding infrastructure grants and strategic planning grants for each of the 50, there's a competitive bidding process right now, and Minnesota is in the process of applying for one of these grants. Where does that come into play with private practitioners? There's opportunity there because they're looking at collaboration between the courts and legal aid, and the private bar. And the private bar needs to come into this to meet the need, and there are going to be portals, and there's going to be a need for referrals, and it's not all about full fee services. A lot of it's going to be about unbundling and alternative service provision to meet the needs of these self-represented litigants who are trying to get help. Now, Sherry and I are doing like a tag team presentation.
So what are unbundled services? It's limited scope services where an attorney provides services without the complete representation needed to meet the client's legal objective, or as was noted, solve their personal problem. Why is it a good idea? Well, as been mentioned, it's really good for access to justice. Many of the clients who can benefit from unbundled services are unable to pay the fees for a full representation and don't qualify at an income level for legal services. It's also good for the lawyer. It brings in business to the lawyer, and a lot of lawyers who use unbundling have found that it creates trust. It establishes a relationship of trust with people who might not otherwise seek out or utilize legal services, and leads to providing legal services down the line in other ways for family or friends, or full representation of that client in some other matter. What are the common challenges? Well, first, it should not be utilized in complex matters. It's really more applicable to relatively simple matters. It's really important that the client understand what is the lawyer is providing and what the client is responsible for. If the lawyer is not comfortable with the client's understanding, or does not think the client can fulfill, the responsibilities expected outside of the lawyer's representation, you really should follow your gut and say, no, this is not appropriate for unbundled. And also, it's really important to have a written, specific agreement about what's being provided by the lawyer. You can always change that agreement down the line if you find that the representation is expanding or changing in some way, but you really want to be very careful to establish what the limits of the representation are.
Okay, I want to talk a bit about ethics of unbundled service provision in Minnesota, since we're talking about how great we are. We have a really great set of ethical rules for unbundled practices in Minnesota, and I know other states are really struggling with the ethical provisions, but in Minnesota, we've got the rules that you would need and hope for unbundled service provision. And our Office of Lawyers Professional Responsibility is very much a proponent of unbundled services. If you go to the OLPR's website in Minnesota, they have a collection of articles and essays, and a lot of those are written by staff of the OLPR advocating for the use of unbundled services because they understand that there's an access issue that needs to be addressed. Their only caveat is you need to they keep saying you need communication with the client, so you need to set out reasonable expectations, and you need to put it in writing. And the other component that they talk about pretty frequently is, as Sherry mentioned, is making sure that the unbundled practice fits the type of case. So you don't want to give a 20-minute phone advice on a complicated bankruptcy case. But otherwise, they're great. They're all for it. And they even have this cool thing where if you're not sure what you're thinking of doing with the client is kosher, you can actually call and get a free advisory opinion. They have a number that you can call, and they'll tell you, they might take a day or so to look into it, but they'll call you back and let you know if that's okay. So there's no reason ethically not to give it a try in Minnesota as long as you follow those rules, and it's articulated in Rule 1.2 and Comments 6 and 7 of our professional responsibility rules.
So I just want to wind up by saying that we have some resources on our website with regard to a variety of alternative fee models and unbundling. The resources include, for instance, limited scope services agreement, exploring the ethical guidelines, some stories and guidelines, some stories for practitioners, and advice for how do you establish your fee, what are the parameters you should consider. So, and also we published in our August issue of Bench and Bar an article by a couple of practitioners who do a lot of unbundled, and Jerry Ford is going to have that at our table tomorrow. So pick that up or take a look at our website. Thank you very much.
Okay, well that was awesome. I think that's really interesting, and with the task force and everything, there's a lot going on here, so it's very exciting. So David Kroll is going to come up last, but certainly not least, and his slides are coming up, and he's going to talk beyond the law firm on a new look at alternative legal service providers. So is Dan still in the room? Is he here? Okay, there we go. So David Kroll, he's spoken before for Evolve Law. He supports TR's legal business, his research and thought leadership, and around the competitive legal tech environment and the changing legal services industry. And he came to TR, Thomson Reuters, sorry, in, just abbreviating from all the emails that I sent, in 2013 in an acquisition, I guess, of Outsell. And so we'll skip past his JD, his locally earned JD, and so his fun fact is that he is fluent in Swedish, and he's an authority on baseball and the law. So
many people are one or the other, but not both.
Not both, but he is both. So David, the clicker should work, and I'm taking, there is an extra drink ticket if anybody wants it.
Okay, thanks. I'll be pretty quick because I know there's drinks and there's a Vikings game going on. Yeah, as Mary said, I want to take this up to a level that's sort of a wider scope than what we've been talking about tonight. We've been talking mostly about the consumer market for legal information, for legal services, and the sort of what you might say is the lower end of the market, smaller firms, smaller clients. But really, the sort of changes that we're talking about here are going on up and down throughout the entire industry, all the way through the largest law firms and the largest clients. And at the end of the day, big companies need better access to justice too. They're complaining about the legal service industry as much as, they have some of the similar, if not the same, level of seriousness of access to justice as consumers do. It's too expensive, it's too complicated to find the right service, it's too complex to use the legal services industry. The thing about legal services is that we've crammed them all into the same container. We think of them all as coming from the same container. When I grew up, you got water from one source. You went to a tap and you poured it out, and you either drank it right away or you took it with you in some kind of container, some kind of jar. But it was free, and nobody ever thought that you could charge money for water. That was, if you're of a certain age in this room, the idea of paying for money seemed really absurd when it first came out. But guess what? Today we have all kinds of packages for just plain old water. Sometimes it's for fine dining, sometimes because it's got bubbles in it, sometimes it's for portability, you carry it with you, sometimes it's for bulk, you buy a big jar of it. So people figured out that you could charge for money if you figured out what the user's use case was, what their application for the water was. And it's kind of similar when it comes to law, that as long as we thought of legal services as only being provided in an hourly container, that limits the scope of development for the industry. But as soon as you start listening to the way people want those services delivered for different purposes, you can come up with all kinds of interesting new containers for them. This is a little image, and I hope it's legible out here, that I stole from Bill Henderson, who is somebody you should pay attention to. He's a law professor from Indiana, and it's a great little model for the legal industry and how it's developed. On the left, first of all, across the bottom, you have the 5 stages that Richard Susskind has developed towards the commoditization of the legal services industry. Chris Anderson referred to Susskind before, from bespoke or custom services to standardized, to systematized, to productized, to commoditized. And it's a spectrum of services that Susskind laid out as a model for the industry, and I think by and large the industry is following that progression in a lot of different ways, in uneven ways of course, but it is sort of a good model, a way to think about the industry. So across the bottom you have those 5 stages. Across the left hand side you have the various sizes and types of clients, from the consumers down in the lower end of that spectrum to small businesses, to larger businesses, regional corporations, global corporations, right? And if you see at that left-hand column is labeled the Artisan Guild. That's the way the law firm industry used to be. Every single client got the same type of service. It was a custom service. Every matter was treated as a custom engagement, and it was all delivered through the same container, the hourly rate. Now what you're seeing is more and more legal services pushing into those two right-hand columns. The middle column being multidisciplinary teams, different ways of plugging in different types of talent and technologies to deliver legal services. So think of something like the one he has labeled New Law is companies like Axiom or Novus Law, who are finding ways to combine technology and services in new ways. The whole LPO managed services industry is sort of in that space. Lean Law is an example of a traditional law firm, Seyfarth, that's taken its process, gone to an extreme in taking its processes and breaking them down so that every type of matter has a well-defined process. And so it's becoming systematized and almost productized. For consumers, the stuff that we've been talking about today, way over on the right, you have, of course, the almost fully commoditized LegalZoom, Rocket Lawyer, that sort of thing. In the middle, though, you're starting to see some other services that are a combination of technology and services, like Modria, which is an alternative dispute resolution service. It's all online. On the upper end, a lot of services are completely technology-based now, but such as the e-discovery software providers. So there's this fairly diverse set of players in the legal services industry other than traditional law firms today. And one of the things that we've taken a look at recently, and we'll have a report from Thomson Reuters are coming out in a month or so, I hope, is a look at that sort of the middle slot there. Who are the players, who are the types of players that are creating new types of legal services outside of the traditional law service model? And this is a spectrum from software providers all on the left, pure software players, to all the way on the right you have staffing, right? So it's really not that much different than the traditional model, except that you're buying lawyers one sort of an engagement at a time. In the middle, you've got all the whole LPO managed service providers, including Axiom and our Thomson Reuters Legal Managed Services business, which is the former Pangea 3. You've also got in the middle law firms figuring out that they can create their own different type of business by spinning out a captive LPO, or by spinning out service centers that are doing parts of the legal work but at a much lower cost in lower cost regions. So there's really quite a lot of variety of experiments in new business models. So as long as we talk about just the consumer end of the spectrum, there's a fairly limited number of solutions that are coming, but some very exciting and interesting ones, as we've heard today. But if you think of the industry in the whole, there's really quite a lot of creative stuff going on, and a lot of ferment that's getting us away from that traditional container of the law firm. We think that this piece of the market is growing at about 8 to 10% a year, compared to plus or minus 0 for the traditional law firms over the past 6-8 years since the crash. Once the recovery came, growth in the traditional law firms has been around 0%. So this is an example of a part of the industry that's really growing and exciting. So it's an example of what you can get when you start thinking outside of those traditional containers and start, as many people have said, by the way, on the panel, if you start with the client's needs, the client's situation, and go from there, rather than start from the provider's needs and their traditional way of doing things. So that's what I had to say about that.
Okay, well, thank you all for listening and for being here. And I don't know if there's any more food, but I think there's a little bit more alcohol, unless you're a big football fan. And so thank you again to Joe and all of our sponsors, and everyone have a good night.
Thanks, man.